My name is Meg DeLuca, and I'm a partner in the private clients group at Cummings & Lockwood. I recently heard that 50% of individuals over the age of 55 do not have a will, and more than 80% of those people have not planned for their incapacity by signing a healthcare directive or durable power of attorney. What makes these numbers so staggering is that 1 out of 6 women and 10 men will eventually develop dementia. So it's more important than ever to plan for your potential incapacity. At its essence, estate planning is the creation of a structure for the management of your personal and financial affairs when you are unable to manage them yourself. This can occur at death or during your lifetime if you become incapacitated due to an accident, illness, or a form of dementia. An estate plan is typically comprised of a will, trusts, durable power of attorney, living will, and a designation of healthcare representative. Wills and trusts provide for the distribution of your property upon your death. They can vary in complexity and can be used to achieve a wide range of personal, family, and tax goals. A properly drafted will and trust plan can minimize conflict among family members by ensuring the smooth transfer of your assets to the next generation, provide divorce and creditor protection for your beneficiaries, manage assets for beneficiaries who may not be able to manage the assets themselves, and reduce estate tax liability. The durable power of attorney, living will, and appointment of healthcare representative are effective during your lifetime and allow you to select an advocate to enforce your wishes if you are unable to make medical and financial decisions for yourself. With a durable power of attorney, you could name a trusted person as your attorney-in-fact to make a wide range of decisions on your behalf. For example, they can handle your financial affairs, such as opening and closing bank accounts, paying your bills, signing tax returns, and buying and selling stocks, bonds, and real estate. Because a power of attorney can give broad authority, it is extremely important to choose your attorney-in-fact wisely. The power of attorney is typically designed to be effective immediately, so it is important to safeguard this document from unintended use. While it's possible to create what we call a springing power of attorney, which only allows your attorney-in-fact to act in the event of your incapacity, this has significant limitations. For instance, if your attorney-in-fact goes into a bank with a springing power of attorney, the teller is likely to say, "Prove to me that this person is incapacitated," and your attorney-in-fact would be forced to go to court to prove your incapacity before being able to use the power of attorney, which is exactly what you wanted to avoid in the first place. If you have a life-threatening emergency, doctors, nurses, and other healthcare professionals will begin life support immediately, unless you decline such measures either verbally or with written instructions prepared in advance. A living will is the document which expresses your wishes with respect to your end-of-life care when you are unable to express them yourself. A standard living will specifies what extraordinary measures, if any, are to be used to keep you alive if you are in a terminal condition or permanently vegetative state. Specifically, you can elect to receive or refuse treatments such as a feeding tube, IV fluids, breathing assistance, and CPR. It is important to distinguish the Do Not Resuscitate Order, or DNR, that you may be asked to sign in the hospital from a living will. While a living will applies only if you are terminally ill or in a permanent coma and addresses all forms of life support, the DNR's sole purpose is to refuse CPR under all circumstances, regardless of your prognosis. An appointment of healthcare representative is the document in which you can name a family member or friend to make healthcare decisions for you if you are unable to do so for yourself. Your healthcare representative will also have the power to enforce the terms of your living will. Because healthcare decisions and end-of-life decisions require your healthcare representative to have access to your medical records, it is important to include language permitting your healthcare providers to release your medical information to your healthcare representative, as required by federal HIPAA privacy rules. For those of you who have children over the age of 18, you should also note that they are no longer minors, and in the eyes of the law, they are deemed to be able to make their own medical decisions. Therefore, you should consider asking your children to sign an appointment of healthcare representative naming you as the representative. Otherwise, healthcare providers may be unable to share information with you, even though you are the parent. Regardless of your financial situation, everyone needs to plan for their future. As people get older, we've found that having well-crafted legal documents can give you great peace of mind in knowing that you've designated the right people to carry out your wishes. Cummings & Lockwood can help.